being scared isn't an excuse anymore. Because if something happens, if I go follow this probation and something happens while you're on this probation, you're looking at the 10-year sentence that you've already agreed to. No negotiations, 10 years in prison. Do you understand? All right, then I'm going to find that you entered your previous plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Also find the prior offenses convictions true that you pled true to. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. The order to pay the
6 years, Judge. It's 10 probated for 6.
Okay, sorry. The PSI has it as 10.
That's right.
So that would have been one of those corrections.
Yes, I apologize, Ron.
6 years probation. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. Clause number 24, DCCR 2353. Mr. Dage was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has, Your Honor.
Yes, Judge.
Are there any additions or corrections?
None from defense.
No, that's that.
So I guess what I'm trying to figure out is the additional case. Was there an assault
Your Honor,
filed also as part of this?
It was not filed, Judge.
it was refused, Your Honor, according to the report, and it's hotly contested on the defense.
Okay. Okay. So that's the burglary that was refused.
Yes, Your Honor. And I know there's a recitation of the facts but those are hotly contested.
Okay. All right. Well, then, I mean, obviously the criminal history gives me a whole lot of concern. And whatever went on that night shouldn't have happened. I mean, I don't understand. In 2019, there was an evading arrest or detention with previous convictions, and he got a 4-year TDC on it. So I guess
The initial offer was for time in this case, Judge, after lengthy discussions with Mr. Lane and the fact that underlying case was refused. I came down with a probation. We respect your opinion on this.
My only brief retort, Your Honor, is these are evading on foot.
but you don't get to keep doing it and then get rewarded for continued bad behavior, right? You don't go to prison for something typically and then get a better deal the next time you do the same thing. You see how that doesn't make sense to me and to most people?
And Your Honor, brief argument, we are asking the court to follow the agreement. Mr. Diggs does have a lifestyle and a plan, work and paying child support, a life now that does not seem like anything that the court is reviewing now. The court does have the mechanism, of course, to really put them in jail for a long time. The moral recognition therapy could work. Any other type programs the court may have. We believe he can do it.
I mean, so I guess the case is from 2024. Have you been out since then on bond? And I got the letter, and I'll take judicial notice to the court's file. It does include a letter that was sent over by your attorney from Mr. Peterson, who I used to work with and trust and value his opinion greatly. And he sent a very supportive letter about you working in that office building and that everyone valued you there. So obviously, maybe you finally figured it out because the criminal history doesn't look like it, but you're older now. A lot of this was when you were younger, but you got to realize that it doesn't matter if you get scared. It doesn't matter what you're doing. If a cop says they want to talk to you for any reason, you would have been talked to them and not been here in felony court if you hadn't ran, So It sounds like this shouldn't be a problem for you. It's just following the rules, going to probation, do your community service, keep working, and you should be fine. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and your probation can be revoked and you would be facing that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lane. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up to her desk when she's ready to go with your paperwork. Good luck to you, sir.
Thank you.
Would you turn that video down, see if maybe it'll kick on?
Terrence.
Good morning, ma'am.
Good morning.
Are you Terriana Frazier?
Yes, ma'am.
And Ms. Frazier, were you able to get someone hired?
Not yet, but I spoke to 4 of them, and I was trying to see if it's too late to get a court-appointed lawyer.
Well, no, it's not. Who'd you talk to?
Thomas Burbanks,
Speak up, please.
Thomas Holmes, Mark Cameron, and James Patterson.
Okay. And are you working?
Oh, yes, I do have.
You do what?
I do have.
Okay, so what I'm going to thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it, okay? Step in front of the clerk on the end. Jonte Harmon.
Yes, ma'am. Don't leave and just permission. Thank you.
Good morning. Are you Jonte Harmon? And this is your initial appearance. Ms. Harmon, in cause number 26, DCCR 0765, you're charged with the second-degree felony offense of burglary of a habitation. And that is from February 6th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right. So are you working? Okay. So what I'm going to do, Ms. Harmon, is reset your case for about 30 days or so to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get here to that attorney and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. You understand?
Yes.
All right. If you step in front of the clerk, she'll give you a reset notice. Nathan Hester. Good morning, sir. You're Nathan Hester.
No,
And Mr. Hester, did you get a lawyer hired?
not yet. We get some money together to get one. It's gonna be right.
You're going to hire Rife. When do you think you'll be able to get Mr. Kimler hired?
A couple of weeks.
Okay. And you've already talked with him and know how much you need? Okay, so I'm going to give you one more reset. You need to get him hired before that next court date, okay? Step in front of the clerk. Marvin Davis. Good morning. Are you Marvin Davis? And Mr. Davis, this is your initial appearance and cause number 26 DCCR 0754. You're charged with the state jail felony offense of injury to a child from February 11th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I talked with 4 lawyers
Okay.
and I talked to Tom Kelly, Brittany Holmes, Sonny Eckhart, and Jameson Bailey.
Okay.
We'll have a job and I have check stubs here. I'm gonna provide like,
Right.
for it, but I do either. I don't really make enough to be able to afford them.
Okay. So what I'm going to do is have you fill out some paperwork this morning, Mr. Davis, to see if you qualify for a court-appointed lawyer. Make sure you fill that paperwork out accurately and completely, and you're going to swear that it's all true and correct, and then I'll take a look at it, okay?
But I have a few questions on the bond condition.
Say it again.
On my bond condition, I know it won't happen now, but I had a question about seeing if I can get like women with bond condition.
Of what?
Of like not interfering with the victim or well the victim that is on this case is in CPS.
Okay, so for now, the bond, you need to, that's one of the reasons you need to get an attorney, talk to them, make sure whatever that bond condition is, where you don't have contact or communication, keep doing that until you get a different order from me, okay?
Yes, and I have my caseworker here as an advocate to
Okay,
advocate for me for that.
perfect. And just because I don't know anything about it other than what the allegation is, we'll leave the bond conditions in place again until, we talk more about it and you have an attorney.
Yes.
So step in front of the clerk on the end and she'll give you that paperwork to fill out. Can Derek Simeon? Good morning. Are you Derek Simeon?
Yes, ma'am.
And Mr. Simeon, this is your initial appearance in cause number 26, DCCR 0457. You're charged with the second-degree felony offense of assault on a peace officer, and that's from February 20th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'll do, Mr. Simeon, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you a reset notice. Good morning. You're Michaela Sylvester?
Yes.
And Ms. Sylvester, this is your initial appearance in cause number 26, DCCR 0766. You're charged with the second-degree felony offense of burglary of a habitation from February 6th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so I'm going to do, Ms. Sylvester's reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order. You would go back to jail. Do you understand?
Yes.
So you and Jonte are co-defendants, right? All right. I just printed something. Y'all both hang on just a second. I want to take a look at something, and then I'm going to give y'all some rules. Did y'all come here today together?
Yes.
All right. Where do y'all live?
Well, we was at Autumn Oak, but we moved out of there like a couple of days ago. So we're going to be at this hotel on College Street till we find another.
How old are y'all? How old are you?
18.
18? 18. So first thing, condition of both of your bonds, if it's not already a condition, is that you guys aren't to be anywhere near the Autumn Oaks apartment. Y'all cannot go anywhere around there. Do you understand?
Yeah.
You also cannot have any contact or communication with Cracia Young or Tyrone Harmon, who I know is your brother.
My dad.
Your dad. And who's Cracia Young?
My stepsister.
Your stepsister. And they're the one, they live over there at Autumn Oaks.
Yes, ma'am.
So y'all need to stay away from both of them for now. Don't talk to them. Don't have anything to do with them. Don't have communication with your dad right now or anything like that. Do you understand?
Yes, ma'am.
Okay. Usually I order that if there's co-defendants, that y'all not have any contact or communication. Do y'all have anybody else to help y'all financially do anything? Okay. So I'm not going to order that, but obviously y'all need to stay away from that situation. If anything else comes up while you're out on bond, where you two aren't getting along and there's some other issue and the cops are called out or you're kicked out of a hotel, then I'm going to order that y'all can have no contact or communication with each other. Do you understand that as well?
Yes, ma'am.
Okay. So whatever's going on, y'all are in felony court now. Y'all are young. You need to grow up, make good decisions, so that you can get your cases taken care of and not be back here in trouble or in custody.
Yeah.
Okay. All right. Did you get your reset notice? Step over here and get your reset notice, then y'all can leave.
Yeah, and then you guys.
You can go. Bryson Grzeski. Good morning. You're Bryson Grzeski.
Yes, ma'am.
And good. Mr. Grzeski, did you get someone hired?
Yes, ma'am. It's just been a payment problem. I'm hiring Rafe Gilmer. He's a family friend of my sister's.
Okay.
So I'm hiring him, but it's a financial thing. I'm self-employed. I have a carpet cleaning van. And so in a few weeks, I'm going to hire him if that's okay with you.
So I'll give you one more reset. That's about 30 days to get him hired. If something's going on and you're not busy enough, you might need to try to find extra work.
Yeah, I got some stuff coming up.
Okay, perfect.
Yes,
So we'll reset you to hire Mr. Kimler. If you'll step in front of the clerk, get that reset notice, make sure you bring it to his office when you get him paid.
Thank you very much.
Michael Pelican.
Thank you so much.
Good morning. Are you Michael Pelican?
Yes.
And Mr. Pelican, this is your initial appearance and clause number 23-41539. You're charged with a third-degree felony offense of unlawful possession of a firearm by a felon. And that's from September 9th of 2022. And since you've made bond in that case, have you had an opportunity to try to hire a lawyer?
Oh, ma'am, I had talked with Mr. Charles. That was my initial attorney.
Mr. Rojas?
Yes, ma'am. But he said he couldn't be my attorney no more because she dropped.
Well, what happens is he's actually still your attorney, but once you make bond, I expect you to try to hire your own. You can hire him, you can hire anyone else. And so what I'm going to do is reset your case about 30 days to give you some time to try to hire someone. If you get a lawyer hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk to give you your reset notice. Tamika Reed. Good morning. Are you Tamika Reed?
Yes, ma'am.
And Ms. Reed, this is your initial appearance and cause number 26 DCCR 0786. You're charged with the state jail felony offense of criminal mischief from February 10th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, they gave me a court-appointed judge.
Right.
I'm going to arraign Mr. Charles.
Yes. So when you're in custody, you automatically get a court-appointed lawyer. So now that you've bonded out, I expect you to try to hire your own lawyer.
I can't afford one. Like I said, I get Social Security, but they stopped my disability.
Why'd they stop it?
I'm on appeal right now. So you know what's going on with it.
Okay. So it sounds like you need to try to get a job then, huh?
Well, I can't work.
Why?
I'm disabled.
Well, if the Social Security Department does not say you're disabled, then there's probably something out there that you can do, right? And so what I'm going to do is reset your case about 30 days to give you some time to do a few things. One, I want you to bring any documentation you have of the Social Security, what's going on with them, appellate papers, whatever you have, bring that in. I also want you to try to find some kind of job and bring me some proof that you're trying to find that. All right. You need to look at least 5 places a week. All right. Step in front of the clerk. She'll give you a reset notice. We're going to get back outside.
The taxes, all of this, 10% person.
Mr. Parker, on Christopher Hunt, that's what this Malfino.
No.
Parker.
It's an initial.
Oh, y'all might not even have.
We don't have anything.
Here, I've got the information from Ashley, so you'll know if you want.
Goodness, no. Sorry.
Okay.
Can't keep it till you know her.
All right, sir, are you Christopher Hunt?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Well, Your Honor.
Mr. Hunt, in cause number 25 DCCR 1766, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. So is it assault family violence?
No, it's just Class A assault, not family violence.
Okay. And that's from September 28th of 2025. And how do you plead to that charge?
Not guilty?
No.
No, guilty?
Yes.
Did you do it or not?
Yeah, it's okay. So are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Do you understand? I'm assuming one of those would also be that you have no contact or communication at all with David LeBlanc. Do you understand? That's obviously in person, but that also means any type of communication. You can't send messages or through social media or anything.
Okay.
That'll be a part of your probation. You understand?
Yeah, well.
Yes.
Okay.
What? All right. So are you a U.S. citizen?
Yes.
So what's the relationship with Mr. LeBlanc?
He was a friend of my mom's.
Okay.
He was staying at my house.
All right. So obviously that's no longer acceptable. You cannot be around him at all, period.
We'll make sure that happens.
Okay. State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Hunt is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and follow all of those rules, at the end of your probation period, the case will actually be dismissed if you're successful. So you won't have the conviction on your record.
Oh,
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You would be found guilty of the offense and you could be sent to the Jefferson County Jail for up to 1 year. Do you understand?
yes, ma'am.
All right, if you'll just have a seat here in the courtroom, probation sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. Just wait for her to call you up.
We thought you were going to call the next one.
Oh, I got to get to that docket. I'll get there in just a second. Don't make me think I'd already said something.
You did. You don't remember?
I don't remember. That could be a problem. See, Stephen Gray, Mr. Parker. Now I'm there.
ma'am.
Good morning. Are you Stephen Gray?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Gray, in cause number 26 DCCR 0294, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from December 27th of 2025. The indictment alleges you were previously convicted of driving while intoxicated June 27th of 2012. And after that was final, you were convicted of driving while intoxicated March 7th of 2014. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
And are those two prior convictions true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. Y'all mark.
$1,000 fine.
Okay.
Sorry. And I didn't put 10 days.
That's a condition that's required. So it looks like the fine would be $1,000. You understand a condition of getting probation is also that you would have to serve 10 days in jail
Yes, Your Honor.
and follow all of the other rules and conditions of probation.
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Gray is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. But what I'm going to do is reset your case for about 30, well, actually, it's to be a little longer than that, so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today. And she's sitting at that desk right over there. All right, we'll see you back at sentencing. Junius Vital.
Your Honor, that's Ms. French's case and it's an unagreed plea. I don't know if you want to wait on her.
Okay, is she coming?
Okay.
Okay. Good morning. Are you Junius Vital? And this is 25 DCCR 1374. Mr. Vital previously was here, entered a plea of guilty to the third-degree felony offense of failure to comply with sex offender registration requirements. The agreement was for half of 4 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yeah, Your Honor.
Yes, Judge.
Any additions or corrections?
None of them were, Judge.
Understood.
All right, Mr. Parker, you may proceed.
Your Honor, Mr. Vital, he's, as far as I understand, he's done a pretty good job reporting for the last 10 years. He's lived around here, and he's also lived in the Houston area. I think the Houston was the last place that he was registered properly. He ended up going to a place called the Wheelhouse. I think that was called the Wheelhouse.
Yes,
in Deer Park area. He tried to register there, but he wasn't actually a resident. He was doing jobs out of there, but he was living in his car. And then when they denied him because of city ordinance, that's why he couldn't live there, city ordinance rules. Then he appealed it and it still got denied. And then he applied. He was going back and forth between his sister's house in Beaumont and working there in Houston. And you tried to apply here in Beaumont as well.
That's where I registered at Beaumont.
So where are you registered right now?
My sisters keep them folks in Beaumont.
In Beaumont.
Yes, ma'am.
And that's where you're living and you are properly registered at this time.
And I believe he's had some issues in the past. He had a substance abuse issue. He's done well with that. I think, he's not one that just ignored what he's supposed to do. I think he's tried, which is way more than I can say for a lot of people. And we're asking the court to give him probation, Judge.
Mr. Smith?
Judge, the state's going to argue for 4 years in prison in this case. The the nature of the previous aggravated sexual assault of a child, I think the facts were fairly aggravating, and he was given probation initially, wound up getting revoked when he committed a new offense, and was revoked and sent to TDC for a 30-year sentence and then a 20-year sentence. It looks like even the PSI notes that even though the criminal history is limited, the circumstances of the offenses are severe. He was given probation in the past that resulted in revocation, and looks like he does try to justify his actions in the PSI interview.
I may respond.
Hold on, I just wanted to, when did you parole out? How long have you been out?
2015.
2015. And so since 2015, there haven't been any issues with reporting or. And it looks like, so while you were since you've been on parole, you've also gone to ISF, correct?
Yes, ma'am.
Okay,
But while I was still in parole, I discharged in 2022.
you did?
And I would just like to say that, you know, part of his revocation was, as according to him, and I think the probation officer, was substance issues. And I think that's part of the reason why he didn't.
Well, yeah, I mean, it was revoked a year after based on a possession case. And that, I mean, I don't disagree with Mr. Smith, but the criminal history, I mean, we're talking about 1991, 1993. We've had 11 years of reporting, and the wheelhouse is somewhere. I understand you're trying to get some help and do some good things, but you understand you can't do that if you can't.
Yes, ma'am.
You have to be able to be somewhere where we know where you are.
Yes, ma'am.
And that you're properly registered.
And that's when they went and denied me out there.
Go ahead.
When they denied me out there, you know what I'm saying, I talked to them. And when I came, I said, I'm just going out there and going, register, back in Beaumont. And then I was still trying to, continue, so working a program.
Right.
Drug and treatment program.
So are you clean now?
Yes, ma'am.
Just double check that this morning, okay? Have a seat in the jury box. I'm gonna have you drug tested this morning. Mr. Parker, you've got Regina Williams, 2 cases.
Yeah, Jared,
I'm sorry.
I haven't done any paperwork on it, but. This is Ms. Malfino's case. We're supposed to be providing Ms. Malfino with an affidavit. We have a copy of the affidavit, but it hasn't been signed. I told her that the person needs to actually go to the DA's office to present to him. So that's where we are. I mean, she showed the document to me today, and I'm trying to get her to get the victim to go, or not the victim, this person to go to the DA's office and sign the document in front of them. And that should resolve the case, but I can't.
Both cases?
Both.
So I mean, this is going to be the last reset. So either they go up there and do what they've got to do. They've got to go to the district attorney's office to do that. You can't just take something for them. They have to go do it. Okay. And if they don't, then when we come back, we'll have to work something else out. All right. This will be the last one.
Don't wait till day before court, because, okay, well, I'm just telling you.
Talk to them and tell them if they don't go take care of this soon, then it's going to be you having some issues here in court next time. Okay. All right. You're free to go.
Thank you, Judge.
Thank you, sir. Mr. Rojas, you got Terrence Currington's the sentencing. Terrence Currington.
Yes.
Bond will be forfeited for non-appearance and reset at 100,000. If you can get in touch with them and get them here, because it's an agreed probation. So I'll consider recalling that forfeiture if he shows up.
Thank you.
Mr. Lewis, you've got Devontre Johnson.
Yes.
Devontre Johnson. Good morning. Are you Devontre Johnson?
Yes.
And this is 25 DCCR 04-8. Mr. Johnson is charged with failure to comply with sex offender registration requirement. And what is the announcement?
Judge, notes on Ms. French's file show that there is a new fair to register case that's in intake right now. So she has withdrawn the 5-year cap offer that she made.
Okay,
So we request a reset.
so that one
The new
should.
case again.
Okay, and but it's already there and it can get taken care of before that next court date, I'm sure, if you'll make sure they know. So what I'll do is I'm going to reset your case about 30 days. It sounds like there is a new charge that could be indicted between now and then. Stay in touch with Mr. Lewis so that he can then get the information on that one, get a new offer from Ms. French, and we'll see where we are at the next court date. All right, you're free to go. Mr. Paget, you have Catherine Bautista.
I can follow paperwork, Your Honor, just a paper chest.
Okay, I'll call in just a second.
You don't mind.
Mr. Samuel and Deanna Paul,
I just had her wait outside and visit with prosecutors.
I'll hold it.
Thank you. Yes.
So do I need
Oh, yeah.
to call this one? What is the, it says, there's that from.
Just to let you know, and at this time, that's, I came, just to let you know, it has. This time.
Like make, and then check mine too. Make check mine. Okay, gotcha. Oh, no, that's fine. Thank you.
Marvin David.
Hey, Mr. Kevin Lane on,
Barrington is arrived. He was earlier on the
okay,
dock.
thank you. I know, I just feel like it's getting stickier and fire. Let's see, okay. I'm kidding there. I already called it and he asked me to wait. Deanna Paul, Mr. Samuel.
Right outside, so. You know, I just visited with the prosecutor.
Hold on, let's get everybody up.
Okay.
Thanks. I said thanks.
Oh.
Good morning. Good morning. Are you Deanna Paul?
Yes, ma'am.
And this is 25 DCCR 1792. Ms. Paul's charged with stalking. And what is the announcement?
Your Honor, I've spoken with the prosecutor. We reached an agreement. We'd like to reset and come back, take care of that.
So it will be up for a plea. I can put it on the plea docket.
Yes.
So Ms. Paul, I'm going to reset your case to the plea docket and we'll get your plea taken care of on that next court date. Stay in touch with Mr. Samuel. He'll let you know when you need to be found. Thank you. You're free to go. Thank you. And is Mr. Rojas, you've got Terrence Currington. I understand he's.
Okay, Jay, we're down all of this.
All right. I'll recall that bond forfeiture. All right, sir. You're Terrence Currington?
Good.
And so, Mr. Currington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right. Mr. Currington was previously in court and cause number 25 DCCR 1114 entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have your own.
Yes, Judge.
Any additions or corrections?
Not from defense.
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you, right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it?
Really?
It is. That's how they give it to you in little plastic baggies.
No, that's, you see.
She's asking for stuff that.
I'm asking you.
Is that?
What? Here's the thing. I'm sorry.
He's in the bag. Plastic bag.
Is that how they give it to you? Okay.
I put it in there
Why would you do that?
for the smell.
For the smell?
Listen,
To block the smell?
right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. Smell like.
Well, how about don't keep it in your car at all?
That too.
That too.
Yes.
So here's the thing. Having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of the probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork. Mr. Burbank, you've got Rakeem Allen, 3 cases. Good morning. Are you Rakeem Allen? Speak up, please.
Yes, ma'am.
And this is cause numbers 25 DCCR 1163, 1164, and 1697. Mr. Allen is charged with evading arrest or detention with the use of a vehicle and 2 cases of possession of a controlled substance. Mr. Burbank, what is the announcement?
Your Honor, I've been talking to Miss Chase about this. Mr. Allen and I had a communication problem in the last couple of weeks. It looks like we have corrected it. It had nothing to do with witnesses, but actually getting into contact. I would ask for one more reset, Judge, to see if we can't knock this 10 years or 12-year cap. And I was talking to Ms. Mofino about another option.
Mr. Allen, do you have the drug patch? I don't see the most recent results. And so I'm going to have you have a seat in the jury box and let's get a test this morning just because I don't have the most recent results. The last one I have was positive. That's fine.
I've got probably 10 positives on him ever since he first had his cases. He keeps blocking out. So I was going to ask you this. Thank you.
Thank you.
He must be in the mic.
Oh, yeah. I remember this. That's unfortunate. Okay. Tiana Hughes, Mr. Burbank.
Yeah, this is.
Good morning, ma'am. Are you Tiana Hughes?
Yes,
And this is 25 DCCR 1058. Ms. Hughes is charged with credit or debit card abuse. And Mr. Burbank, what is the
I
announcement?
hate to tell you just one, a reset, this will be dispositive, needs to get her money together. She had had some problems with the bank and some other stuff, rough with straightening out, but she has corrected that. So if I just get a normal reset, it should be finished next time.
Okay. So any issues?
No, Your Honor.
All right, we'll just do a normal reset, Ms. Hughes. Make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back for that next court date. Okay, you're free to go. Cody Litchfield. Good morning, you're Cody Litchfield. And this is cause number 26 DCCR 0646. Mr. Litchfield is charged with attempt to commit arson. And Mr. Burbank, what is the announcement?
I am not finished with discovery. I'm trying to get some video of this through the fire department in the county. And so that's why I'm.
Any issues, Mr. Nichols?
No, Your Honor.
All right, we'll just do a normal reset. Mr. Litchfield, stay in touch with Mr. Burbank. He'll let you know when you need to be back.
You're free to go.
You're free to go. And Crystal Robertson. And then don't leave after you're done when I've mentioned something. This is Mr. Coleman's case on a Crystal Robertson. Good morning, ma'am. You're Crystal Robertson.
Yes, ma'am.
And this is 25 DCCR 1526. Ms. Robertson is charged with forgery of a governmental instrument. And what is the announcement?
Your Honor, she is in between jobs. What I mean by that is she has a job, she's just gotten a better job, and there is a bonus. She's going to a government entity. This is a case of restitution and then solution for file disposition. So I would ask Judge, and that was the intent of the prosecutor and myself, so that we can get this by her so she doesn't have any felonies.
When do you anticipate?
July.
Okay, so we'll just do a normal reset.
Yeah, sure.
And so, Ms. Robertson, I'm going to reset your case normal about 30 days or so. Stay in touch with Mr. Burbank. He'll let you know when you need to be back. All right.
Okay. I think that's all.
Are you pleading guilty? Mr. Parker? Mr. Vitale? All right, we're back on the record in cause number 25 DCCR 1374. Mr. Vitale tested positive for cocaine. So, Mr. Vitale, you've been to ISF twice while you're on parole. So parole's given you two opportunities not to revoke your parole. And you get off parole and here you are with another felony and you're using cocaine again.
You need some help, Mr. Ma'am.
I'm sorry?
I just need help.
Well, you've gotten the help and you're looking at a cap of 4 and I was well on my way to giving you an opportunity. But there's no way I can do that with your criminal history and the fact that you've been given, because if you hadn't been to ISF, I'd say, okay, maybe I'll send you to ISF, but you've been twice in the last 5 years. All right, at this time, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of failure to comply with sex offender registration requirements. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff. Mr. Paget on Catherine Bautista.
Yes. Good
morning.
Good morning. How are you?
You know, the gentleman that was up there that works in Tommy's office,
Uh-huh.
I could have testified for
Said the same thing.
you guys that does what he says there.
Well, that's what,
I've never moved from the office I was when you first.
oh,
So,
good morning. You're Catherine Bautista. And will your client waive the formal reading of the indictment?
she will, Your Honor.
Ms. Bautista, in cause number 25 DCCR 1608, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from September 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 3 years. You would be ordered to pay a $300 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections to stage 1, Your Honor.
It's admitted. Is there any evidence that Ms. Bautista is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty.
There's one, she had a case 10 years ago that ended as a state jail revocation, but that's it, Judge. I don't see any reason
Not to waive.
not to waive.
All right, so Ms. Bautista, I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty, and at this time, find you guilty of publishing or threatening to publish intimate visual material. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated. You'll be on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 2-year sentence that you've agreed to. Do you understand?
Yes, ma'am.
And I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. It's printing, I think. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Paget.
Yes, ma'am.
So if you'll just have a seat here in the courtroom, probation is sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. So watch for her to call your name.
Okay.
All right. And if you'll make sure and send that attachment over.
Diane, it's like asked her to, but it was fine. But Judge,
Okay, yeah.
whether or not to.
The
Yeah.
situation was we
Only did it because he was having trouble accessing it.
Okay.
We talked prior to court.
Okay, all right.
She's saying.
And that's why I couldn't see it this morning. I tried to print it.
Maybe-
Blank for you
It was
too.
blank.
We go ahead and write it out.
Yeah, if you'll just get a sheet of paper and write it out.
Sure.
Mr. Burbank, that's his, how he takes care of his. But if you'll write it out real quick.
Yeah, I don't have a problem with it.
Yeah, just because we can't close it out since I sentenced her today. And so if you'll do that before you leave, that'd be great. Thank you.
I'll be nice.
Paper and then-
I tried on. Here's what it is.
Your Honor,
Yeah. Let's see, Rakeem Allen. All right, yes. Okay, Mr. Allen tested negative. So obviously that's good. You need to continue to test negative. If there's a positive drug screen that comes back, those bonds are going to be high enough to where you can't make them. All right, so we've gone through this too much, but I don't have any, but it looks like you've finally gotten the message that you can't use while you're out on bond. So we need to reset then.
Yes, Your Honor.
Just a normal reset. All right, stay in touch with Mr. Burbank. Talk to him well before that next court date so that we'll be prepared on the next court dates for you guys to make an announcement, okay? All right, free to go. Yes, thank you. Mr. Gertz, you've got Miguel Martinez. And this is Ms. French. Good morning. Are you Miguel Martinez? And this is 25 DCCR 0584. Mr. Martinez is charged with aggravated sexual assault of a child. This was the last reset. So what is the announcement?
Judges, you know, I've been in trial the last several weeks. I got an offer toward the end of last week from Ms. French. It's a pretty daunting offer. We are not intending on going to trial. What we're asking is 2 weeks to allow him to get his sort of affairs in order, to explain what may be the parameters to his family, all of those things. But we're not going to come in and announce trial after that.
Okay, so
it's going to be some kind of resolution. I just don't know if we're going to accept this deal or potentially plead open to the court.
But it'll be a plea in 2 weeks.
I anticipate it will, Judge.
All right, we'll reset it for a plea in 2 weeks. Mr. Martinez, make sure you stay in touch with Mr. Gertz, and then we'll get it taken care of at the next court date. Mr. Gilthorpe, did I sleep? On Marco Morales.
That was all.
Uh-huh.
I find Mr. Church is here. There's some confusion about it being this case from 2 weeks ago being reset about bond hearing. We already had
I don't have it on the docket.
we already had the conversation with him about. Okay.
Yeah, I wouldn't think that.
Shut up, sir.
Yeah, that.
Shut up.
Good morning. Are you Marco Morales? And this is 26 DCCR 0160. Mr. Morales is charged with evading arrest or detention with the use of a vehicle. Mr. Gilthorpe, what is the announcement?
If I could have one reset to negotiate with Ms. Mulfino, she has already extended an offer. But she and I had a discussion. We were just seeing if something else would work.
Okay, so I'll
I anticipate a plea.
I'll reset one more time to give you some time to get that taken care of. Mr. Morales, make sure you stay in touch with Mr. Gilthorpe so that you know what's going on, and we'll get an announcement at the next court date. Okay, you're free to go. Yes, sir. Ms. Holmes, you got Kristen Bell.
Better. You get it. Worked out. Thank you.
Okay, good. Thank you.
Good.
You too.
4 days, 3 times.
Good morning. Good morning. Kristen Bell is Miss Mulfy. I'm sorry, it's Miss French's case. Good morning, ma'am. Are you Kristen Bell?
Yes.
And this is cause number 25 DCCR 1812. Ms. Bell's charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, this is our first setting. I originally had received a no offer from Ms. French that she wanted to get more information on CPS records. And then she sent me a revised offer Friday.
Okay.
I haven't had a chance to move forward with Ms. Bell.
All right, so we'll just do any issues that you see, Mr. Smith. We'll just do a normal reset. Ms. Bell, make sure you make an appointment, go visit with Ms. Holmes before that next court date so that you can be prepared for an announcement at that time. All right, you're free to go.
Thank you.
Yeah, Ms. Warner on the end, she'll give you a word. Kenneth Cormier. This is Mr. Coleman's case on Kenneth Cormier. Good morning. Are you Kenneth Cormier? And this is 25 DCCR 1113. Mr. Cormier is charged with obstruction or retaliation. What is the announcement?
Your Honor, I know this case is getting a little old.
It's getting way old.
Yes, ma'am. If we could get one more, we're close. There was some mitigating factors I wanted to give as far as employment and everything for Mr. Cormier.
Here's what we're going to do. I'm going to reset it 2 weeks. So whatever needs to take place in those 2 weeks, this will be the final reset. Mr. Cormier, if there's any information that you have that Ms. Holmes needs, you need to get it to her quickly so she can get it to Mr. Coleman so that we will get an announcement one way or the other the next court.
Yes, ma'am.
All right. Thank you. Okay. You're free to go, sir. Courtney Jones, signing a dismissal in that case right now. She's free to go.
Okay. You.
Thank you. Looks like that's all you got.
Yes, ma'am.
And then Logan Eaglin, I'm sending a dismissal because that's not on today's docket. Is it? Okay. Got it.
Okay.
We haven't seen Mr. Jeffries yet. Oh, okay.
Okay. Thank you.
What about Mr. We've seen Brian.
No.
Mr. Mitchell, you have Kevin Boyd.
Yes, we just worked out play agreement on.
I'll hold it.
I'll get the paperwork out, Dutch.
Thank you. And then what about Henry Littlefield?
Right there, yeah. Can I hold on that, Judge, with all prosecution? But
Sure. Michaela Collier, Mr. Kimler, and Mr. Nichols. Are you Michaela Collier?
Yes, ma'am.
So this is 24 DCCR 0751. Mr. Kimler, I don't see that you have filed anything that I requested get filed before today.
I didn't understand why I have to file a bill. I mean, it was an illegal sentence. I mean, she never should have received the sentence. They couldn't, the court have the power to vacate the sentence.
No, I don't without a motion.
I filed a motion to vacate the sentence, yes.
I don't see it.
That's how it's come to our question.
It's not.
I think there was a motion.
Not a quash. That's not, and that's why I sent you. And I talked to Mr. Florence, and you said that you were going to talk to Mr. Florence. And we did all the research, and I've done all the work for you, which is very frustrating.
All the work I filed the writ.
Before today. And I mean, literally 3 days after court, I handed you on a silver platter, here's what you need to file. You emailed back that you would talk to Mr. Florence if you had any questions and get it filed. So today, what can happen is if you would like to make an oral motion for me to vacate all of the proceedings, I would entertain that oral motion.
Yes, I think I filed a written motion to vacate along with the beginning of the case.
To vacate or to quash?
But maybe, I thought it should be to vacate. I don't know, maybe to quash the NTRP. I don't know.
It's a motion to quash. Would you like to file an oral motion to vacate all of the proceedings?
Yes, sir. I'll move at this time to vacate the prior proceedings in this case based upon the fact that it was not a knowing voluntary plea, since she was pled to what she believed to be straight probation, which was an impossible or illegal plea, and that her decision to enter that plea was therefore based on I would say ineffective advice or ineffective information. So it's a voluntary plea.
So what I can do at this time is grant that oral motion to vacate as a writ under 11072. And so I'm going to grant that motion and treat it as a writ of habeas corpus under 11.072. I'm going to vacate all of the prior proceedings. And so we are now starting at step number 1. And so I'm going to reset the case for an announcement. Ms. Collier, make sure you stay in touch with Mr. Kimler. You need to be back at your next court date for an announcement, and we'll see where we go at that point. All right.
You mind, since you vacated, I don't need to do a motion to dispose of this NTRP. It's been.
You shouldn't. It should be, everything should be vacated.
Okay.
And I'll double check if there's anything, but we'll do that. And I need a sticky note on that for.
Judge, I think what happened was the prosecutor was on this case. I think resigned and moved on. And so I was dealing with her, and I think I didn't know she had left. And so I reached out to the chief to address this issue, and I know he's on it. It's crucial for us, Judge, because
I can appreciate it. It's just on the trial docket, it's a year and a half old, and y'all are looking at how long is this going to take?
if we get one more trial setting, Judge, another 4 weeks, so we can get it. We'll know for sure one way or the other. Sure. Thank you.
Desmond Limbrick. Brett?
Judge, that's going to be a great
Hey, Judge, if you want that no read a third case along the trial, I had all the papers.
Yes, you're right.
That's ready for you. I can do that for you right now. That's on the trial docket.
Really? Do you need to go somewhere?
No,
you want to do it first?
I was going to do it. I know
we're going to do it, right?
It's on the trial docket. We can go.
Just trying to feel you out there. Yeah, we'll get let me just go through it. I'm almost through, and then we'll.
That's cool.
Mr. Limbrick is here. I'm doing paperwork.
Okay. On
Desmond Limbrick. Should be on the second page, I think. We said someone on mine.
Yep, it's bottom of the first. You know what? This I've got two dockets. I've got an old docket and a new docket.
Okay. Well, Mr. Limbrick, as we're doing paperwork, it's going to be a.
Christopher Broughton. That's is it old? Mr. Giles. It looks fine. He's going to go on. Christopher Broughton. There's no answer in the courtroom. I asked the bailiff to call into the hall for Christopher Broughton. That's Miss Moore. That's your case, right? Yes. Have you talked to Giles lately?
Not lately.
Okay, that's still on the docket today, right?
That I know of, so.
What is it?
Yes, it's still on the docket.
That's the way it all is. It's may or may not happen. Christopher Broughton? Is that you? Giles Cole is representing you, right?
So
Where is he?
I've been trying to contact.
You've been trying to get him today? Has he answered?
But they're done.
Okay. All right, we'll try to get him. I've got a special number. Okay, just hang out there close by. Thanks. Roger Carter. Roger.
Great.
That's Mr. Laird, right?
Yes, sir.
On Carter, announce ready.
Yes, sir.
What he's saying? Okay. Christopher Hino. That's the last name.
He's here.
Chris.
He's in the back. Coming up.
Yeah. And?
On him.
Yeah, on him.
If you don't mind.
If I don't mind.
Still trying. That one is just like 200 something. Can I just have one resale?
Actually, right at 300.
My bad. I didn't misread it. But
I just enjoy him kind of. Okay.
I have my mind on right and left, just at the top. Okay, so that's the direction.
At least it's not on golf. That's not good. How much time?
Just a normal 4 weeks.
This is the criminal district court. There's nothing normal in this one.
And I'll try to get with Mr. Hare too. We're
going to reset it for 4 weeks, okay? Langston, okay. Get it reset.
Thank you.
Don't see you next week. Diosdado Perez, right?
Just
Diosdado.
Thank you.
There you go. We're going to do that now. Really? On this one? I'm thinking this. Have you seen this? You've seen it. I know you've seen it.
Yeah, I've read the description. I watched the videos.
Oh, you've seen the video? I didn't see the video. Okay. It's a prohibited weapon. Is that what that sounds? And grown. Where I used to live. Going out and things, even how I just hear and say so, but then you claim.
It was allegedly a destructive device, but it was more pyrotechnic than
you call emotion. That's just not.
I know, but the facts will speak for themselves.
So this one's going to be interesting.
That's it.
Right.
Sure.
Oh, yes, this one. Oh, yeah. No.
Yeah, that's true. Good next day. Still doesn't Justin, right? Well, we put down what there's different schedule.
Well, apparently when they go into the car and then lock the door and wait and see what happens.
Yes.
Yeah, the fan. Well, you've read this. And then
you'll love the video.
There's nothing destroyed.
No, but
doesn't
still,
have to be anything destroyed.
You don't have to destroy anything. But the thing is what we want is a family that doesn't have explosive devices at the house. When we're drinking, and everybody else is sitting in the car, scared to death. Are y'all ready? Are y'all ready on this? Yes, for Davis.
We're pleasing. That's the word.
And finally, I got Sheena Miller again.
Sheena? Still trying.
Yeah. Where's Sheena? Sheena, that's her. Yeah.
You want him to sit down?
Oh, yeah. I do. And don't light anything. Sit down in there and don't light anything.
Sheena Miller. No, sit down.
Yeah, you can sit down. How many police? You have 2 or 3?
There's one with lights and one with
Yeah, we're gonna get let me just take care of this and then we'll system.
Yeah, this is a trial. So this is
Actually, yeah, but there's 5,000 of them. I gotta.
Nothing's changing. This
I just can't remember them all.
will give you a sticker.
I don't see any prior criminal history. Might be awesome. What do you want?
I think that one of the good offenders.
Well, what
Yeah,
happened
he's
on
still
that?
out on the watch.
Thanks for filling this. Now they can find it. They'll find it. All right, well, we'll review this in 4 weeks, okay?
Thank you, Judge.
Yeah, let me get your police real quick. I got Jessica Wright. And then I got Esther. Jessica. I'm ready. I got 2 cases, right? What are we gonna? We're ready. What's gonna get dismissed?
No.
It's a plea on both of them, Judge.
We do on both elements.
Please raise your right hand. Swear to walk around the color. Right thumb French. Gotta eat up more than that. He's still got a warrant like one night under your fault.
Yeah. Here's just insert something. Okay.
She wants to.
Hey, Brent, I don't see anything in the queue on Limber.
I just sent it to Jimmy.
Okay, and
Should be on the way, Judge.
I don't see anything on Esther.
That should also be on the way.
Okay. 2 cases are now called 23 CR 757 and 25 CR 928, the state of Texas versus Jessica Helen Wright. That's you? Present. With, you got a gaggle of attorneys here.
Is that what it is?
That's what we tell them, more than one is a gaggle. Okay. That's pride of lions. It's gaggle like in geese. It's a gaggle of geese. All right, who's handling which one?
Langston's on the DWI, Rife's on the theft.
All right, on 23 CR 757. We've got like a ton of prior convictions here. On Jessica's case. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary on 756? Yes. You're on it? I saw who was on it.
I'm sorry.
You know, it'll make a great act. I'll tell you. I see this on late night shows and I laugh. Okay, In summary, paragraph 1 alleges that on or about December 29th, 2022 in Jefferson County, Texas, you committed the offense of theft. Do you understand what you're charged with?
Yes.
Paragraph 2 goes on to allege that you have 2 or more theft convictions out of county courts at law. County Court at Law number 2, 2 convictions in 1996. And then on August 4th of 2014, in the court next door, the 257 District Court, you were convicted of theft. Paragraphs 1 and 2 constitute a state jail felony. Do you understand? But we're not through. We've got 1, 2, 3, 4, 5, 6 6 other felony convictions of forgeries, controlled substances, and y'all got this as a 3rd-degree felony. So
We just need
is it paragraphs
You have to be sequel. 3
3 and 4?
It would need to be sequenced.
No, that'd be second. No, these 3 and 4 are on the same date. That's what makes it a third.
I understand. So we're going with the state jails.
Paragraph 3 of the indictment alleges, as well as paragraph 4, that on April 10th, 2001, in this criminal district court of Jefferson County, Texas, 2001, I think I was in high school then, in cause number 71569 and 71607, you were convicted of the state jail felonies of forgeries. Do you understand what you're charged with in paragraphs 1, 2, 3, and 4? This constitutes a state jail felony, punished, though, as though it were a 3rd-degree felony because of the prior convictions, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Hold on. State jail. Okay, an agreement's been reached where you would be sentenced to 6 years in prison. Is that your understanding of the agreement for all of this?
Yes, sir.
If I follow this, you have this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
And I guess the agreement is it's going to run concurrently
Yes.
with another case.
Both of these cases are running concurrently.
The concurrent part is on the DWI.
Well, I think it needs to be on this one too.
Well,
They need to run concurrently with each other.
If it's on one, it should cover the other.
You could
Look,
write
I'm gonna
it.
add this just to be on the safe side, so that later on, if she comes up for parole, they go, well, no, this doesn't say that, and they don't look at the other people. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir. So, in this cause number 23 CR 757, how do you plead to paragraphs 1 and 2, guilty or not guilty? Guilty, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those prior convictions of thefts out of county court at law number 2, in 1996, 2 cases, and 1 case August 2014 in the 252nd District Court of Jefferson County, Texas. Are those allegations true and correct as they are alleged? And are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes.
And paragraphs 3 and 4, the prior convictions of forgery in 2001 in this criminal district court, Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct in each of these cases voluntarily and because those allegations are true?
Yes, sir.
And again, this constitutes a state jail felony punished as a 3rd-degree felony, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And once again, the agreement is you would be pleading guilty, sentenced to 6 years to run imprisonment to run concurrent with another case. Is that your understanding of the agreement?
Yes, sir.
And are you pleading guilty in this case voluntarily and because you are guilty as it is alleged? Let's show you what's marked as State's Exhibit 1. In this case, did you sign that document, understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. It's admitted. What this states, as well as the proceeding case, the same statements, and it will be State's Exhibit 1 that we will introduce here in just a minute in cause number 25 CR 928. This states in both cases that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with in each case. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial in each of these cases. And you were guilty of the crimes in any lesser included offenses. You were giving up your rights to the cross-examination and confrontation of witnesses, and you were guilty of each of these cases. So help you God. State's Exhibit 1 in each case will be tendered without objection.
We've already made it.
Admitted. All right.
I'm sorry to see this cold from the less than certain. You were actually getting me touched. This is what
And finally, in 25 CR 928, does the defendant waive a formal reading of this indictment?
Yes, sir.
And arraignment, can we proceed in summary?
We're just proceeding on paragraph 1 in this case, Judge.
In summary, it's really kind of two.
Or paragraph 1 and 2. What constitutes a 3rd-degree felony, not an
Okay.
enhanced path?
In paragraphs 1 and 2, paragraph 1 alleges that on or about December 2nd, 2024 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that in 2007, 2012, and 2012 in Orange County and Jefferson County, Texas, respectively, you were convicted in each of the county courts of law in those counties for the offenses of operating a motor vehicle while intoxicated in 2007 and 2012 before you were charged and committed the offense in paragraph 1 on December 2nd, 2024 in Jefferson County, Texas of a DWI. Paragraphs 1 and 2 constitute a 3rd-degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. And an agreement's been reached in your case as well. Here, you would be pleading guilty, sentenced to 6 years in prison to run concurrently with the preceding case 757 that you pleaded guilty to. Is that your understanding of the agreement?
Sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Have you pleaded into paragraphs 1 and 2 constituting a 3rd-degree felony of operating a motor vehicle in a public place while intoxicated? Guilty or not guilty? Pleading guilty voluntarily and because you are guilty.
Yes, yes, sir.
Okay, I'll show you what's marked in this case. Stacy, Exhibit 1, did you sign that?
Yes, sir.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes.
States Exhibit 1 tendered. No objection. Without objection admitted. Similarly, as before, the states you were mentally competent to enter your guilty plea. It's freely and voluntarily. You know what you've been charged with. Your indictment's been read to you. You read it. You were guilty of the crime charged and any less included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, consultation, cross-examination of witnesses, totally satisfied me with the representation by your lawyers in each of these cases. So help you God. All right. States Exhibit 1, made a part of the record in each case. Pre-sentence reports are waived.
Your Honor, I think she had wanted before.
I just have a couple of pens in my apartment to get together. I didn't know today was going to be final sentencing where I was going to get booked in or anything, but it just needed a week.
Okay. She speaks softly. I didn't hear everything.
She's a week to get her affairs in order.
What do y'all say?
Number of pets and.
This is odd, but.
Usually this is done before the plea is entered.
We could just sentence her, maybe reset sentencing for a week.
We could do that for Monday. There's a docket on Monday, Judge.
I'm going to make the following findings in each of these cases. That you have pleaded guilty in each of these cases voluntarily. You are mentally confident to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty in each of these cases to find you guilty beyond a reasonable doubt of a state jail felony punished as though it were a third-degree felony in the theft of property case in 23 CR 757 and in the third-degree felony in 25 CR 928 of a felony operating a motor vehicle while intoxicated in a public place. I now find you guilty beyond a reasonable doubt in each of these cases. I'm going to postpone the sentencing until when?
Monday.
1 week from today?
It's 29.
Stand by.
That's it. That's all we have.
Yeah, I think that's next week is the July 4th holiday, and I think there's going to be some July 4th. It comes every year. It's a very system. Yeah. The July 4th holiday is coming up, but
We just docket on Monday.
but we have a docket next Monday, a week from Monday. And I think part of that week, it's going to be closed for the July 4th holiday. So we will set it for 1 week from today. Be here, and we will take up the matter of the formal sentencing. Okay? Please note that.
It doesn't appear you can get charged.
Yeah. And those always run consecutively. So don't trail off. Thank you. Yes, ma'am. That was, yes, ma'am. I have Roger Carter. Where'd he go? Hey, Roger Carter, is he ready? We're ready.
Yes, I'm ready.
Okay, Roger Carter. Thank you.
I just assumed trying, she got help and all. Like, you're not trying to
Has he been sworn in? Uh-oh.
He's not pleading.
He's not pleading. I don't know what this, I don't know what.
Hold on.
It's on the trial docket. We both announced ready later.
Oh, it's on the trial docket?
Yes, sir.
Okay.
Ready.
Sorry. We're going to have him on the trial docket. Yeah. What did you have? You have
Esker Davis.
Esker Davis is who we'll need.
Davis.
And he's out in the crowd.
What's your stuff? Oh, that's you. Sure. That's done.
You need to go in front of me?
Yes.
Right here. That's awesome.
Raise your right hand, please. Where we're going. Okay, so leave your right thumb print up. You're getting more than that. Right thumb print. Yeah, okay. Place it flat right here on the box. Don't hold it. Okay, one more time. Right side. Yes.
Hey, Brent, we're still on Limerick, right?
Yes, sir.
Okay, he'll be up next.
Okay.
On 25 CR 1491, does the defendant Escar Wayne Davis, that's you, here with your attorney, Mr. Kimber, and the state's attorney, waive a formal reading of the indictment and arraignment here, which are parts 1 and 2 of this indictment? And can we proceed in summary?
So waived, we may know.
In summary, sir, paragraph 1 alleges that on or about September 11th, 2024 in Jefferson County, Texas, you committed the offense of operating a motor vehicle while intoxicated in a public place. Do you understand what you're charged with there?
Yes, sir.
Now, that would be generally a misdemeanor, except paragraph 2 goes on to allege that you have two or more prior convictions. It states that on October 19th, 2011, out of County Court at Law 3 of Jefferson County, Texas, you were convicted of a DWI. And in 2012, in this criminal district court of Jefferson County, Texas, you were convicted of another operating a motor vehicle while intoxicated. So paragraphs 1 and 2 constitute a third-degree felony. Do you understand what you're faced with in this particular situation?
Yes, sir.
You must have had there must be another DWI in there.
My second one was child baptism. My second one.
Okay. Yeah, it's not alleged in here. It only takes 2 prior to become a third-degree felony, but you've got this felony was already in here, which meant you had 2 prior somewhere. All right, this indictment, paragraphs 1 and 2 constitute a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? The punishment range.
I guess it.
An agreement's been reached. In your case, you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
So how do you plead to this indictment, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those prior convictions of DWIs, County Court in Law 3 of Jefferson County in 2011, and in this criminal district court of Jefferson County, Texas in 2012. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because they are true as they are stated in the indictment?
Yes, sir.
I'm going to show you what's marked as States Exhibit 1 here. Would you sign that document, understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. It's been read to you. You've read them. You were guilty of the crime charged in any lesser included offense. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived. Good move. Okay, if nothing further, I'm going to find that you are pleading guilty.
This courtroom hearing centers on a violent assault allegation that left a man seriously injured and led to the authorization of multiple criminal charges. According to the testimony presented before the court, what began as a confrontation between several people allegedly escalated into a brutal attack. Investigators described how Jordan Dameron was found badly injured after the incident, with witnesses providing information about the events leading up to the assault. Testimony indicated that the defendant, Mr. Higgins, had allegedly been involved in the confrontation and was reportedly seen with a handgun before the situation turned violent. As investigators began piecing together what happened, the seriousness of the victim's condition became impossible to ignore. Jordan Dameron was taken to the hospital, suffering from significant injuries. According to testimony, his injuries included a brain hemorrhage and 2 fractures to his jaw. The damage was so severe that his jaw reportedly had to be wired shut, making it impossible for investigators to interview him directly. His family also reported that doctors believed the injuries were consistent with blunt force trauma caused by a foreign object, potentially a firearm. One particularly important part of the testimony involved what witnesses allegedly heard after the attack. Initially, there was discussion about whether the victim had been struck with a baseball bat, but according to the testimony, a witness heard a male voice, allegedly recognized as Mr. Higgins, say that he did not hit the victim with a bat, and instead claimed that he had hit him with his gun. That allegation became a critical part of the evidence being presented to the judge. The court was not conducting a full trial at this stage. Instead, the judge was listening to sworn testimony to determine whether there was sufficient probable cause for the criminal case to move forward. That is an important distinction. The judge was not deciding guilt or innocence beyond a reasonable doubt. The immediate question was whether the evidence presented established enough grounds to formally authorize the charges. This courtroom hearing centers on a violent assault allegation that left a man seriously injured and led to the authorization of multiple criminal charges. According to the testimony presented before the court, what began as a confrontation between several people allegedly escalated into a brutal attack. Investigators described how Jordan Dameron was found badly injured after the incident, with witnesses providing information about the events leading up to the assault. Testimony indicated that the defendant, Mr. Higgins, had allegedly been involved in the confrontation and was reportedly seen with a handgun before the situation turned violent. As investigators began piecing together what happened, the seriousness of the victim's condition became impossible to ignore. Jordan Dameron was taken to the hospital, suffering from significant injuries. According to testimony, his injuries included a brain hemorrhage and 2 fractures to his jaw. The damage was so severe that his jaw reportedly had to be wired shut, making it impossible for investigators to interview him directly. His family also reported that doctors believed the injuries were consistent with blunt force trauma caused by a foreign object, potentially a firearm. One particularly important part of the testimony involved what witnesses allegedly heard after the attack. Initially, there was discussion about whether the victim had been struck with a baseball bat, but according to the testimony, a witness heard a male voice, allegedly recognized as Mr. Higgins, say that he did not hit the victim with a bat and instead claimed that he had hit him with his gun. That allegation became a critical part of the evidence being presented to the judge. The court was not conducting a full trial at this stage. Instead, the judge was listening to sworn testimony to determine whether there was sufficient probable cause for the